The legal sale, California probate requirements. You accepted an offer. The buyer is excited. You're relieved. You think the house is basically sold. Then your phone rings and you find out that one simple mistake can derail everything because you forgot to inform your attorney that you got an offer and that NOPA never went out. Now, the timeline resets, the buyer gets nervous, and the deal can fall apart. Hi everyone, I'm Paula Aragone, founder of Aragone & Associates, Orange County premier real estate group. At Aragone & Associates, we maximize value and minimize stress. And remember, strategy is what we do. Welcome back to Mastering the Probate Sale. We've done the hard part. We've cleared the house, we've navigated family dynamics, we marketed the property, we've secured our buyer. Now we enter what I call the legal sale. Because in probate, a signed contract does not automatically mean a closed deal. Today, I'm decoding 3 things that protect your timeline and your liability. Number 1, the 15-day notice of proposed action, NOPA. Number 2, the 90% probate appraisal rule. Number 3, the disclosures that protect the estate and protect you. The reality check. Probate is not a normal sale. In a standard sale, you sign the offer, open escrow, and you close. In probate, you have a fiduciary duty. You can't sell the asset in secret. You have to follow a process that is transparent and defensible because beneficiaries pay attention when real money is on the line. Even if everyone seems fine, they still have legal rights. So here's the mindset shift. In probate, your best protection is speed. Your best protection is process. The 15-day NOPA, what it is and why it matters. If your probate is under independent administration with full authority, you often don't need a judge to confirm the sale in court, but you usually do need to provide formal notice to the required heirs and interested parties before you can close. The notice is called the Notice of Proposed Action, the NOPA. Here's the simple version. Once the offer is accepted, the NOPA is prepared and sent to everyone who must receive it. It basically says, I'm selling the property for this price on these terms. If you object, you must object within the notice period. Now, the notice period is 15 days from when it's mailed or delivered. And in real life, with mailing times, we often account for 17. If nobody objects in writing, you move forward and you close. If somebody objects, now you're not just not closing escrow, you may be moving towards a court process. And that's why I call this phase the legal sale. Your timeline is not just market timing, it's legal timing. Where executors get blindsided. Here's the part that causes problems. Someone assumes everybody has agreed, so we're good. But probate doesn't run on assumptions. It runs on notice and documentation. If the notice doesn't go out or doesn't go out correctly or goes to the wrong address, you can lose weeks. And in a market where buyers have options, weeks can be the difference between closing or having a cancellation. Full authority versus limited authority. Now, if you have limited authority, the sale typically requires court confirmation. That means more steps, more time, and a different buyer expectation. This is where you start hearing, why is it taking so long? Why are we waiting for a hearing? Why can't we just close? Because court confirmation, you're not negotiating a deal. You're preparing a sale at the court that the court must approve. And that is why we have the 90% rule, and this becomes critical. The 90% probate appraisal rule, what people get wrong. Now let's clear up that rule that gets misquoted all the time. The 90% rule is the threshold tied to the court confirmation. If your sale is going through court confirmation process, the offer generally needs to be at least 90% of the probate referee's appraised value in order to be confirmed. But if the estate has full authority under IAEA, you're not automatically locked into the 90% floor because the sale can proceed without court confirmation. So think of the 90% rule like a fork in the road. If you're under court supervision, the 90% threshold matters immediately. If you're under full authority, your job is still the same. Get a defensible price, run a transparent process, and protect the estate. And here's the practical advice that keeps you out of trouble. Even with full authority, you usually want to stay at or above that 90% benchmark, unless you can clearly justify why it's below. Because if you can't justify it, that's when beneficiaries object, and that's when a sale that could have been smooth gets pulled into court. So if you ever accept less than the benchmark, you want a clean, documented reason, like market conditions, property condition, repair estimates, inspections, finding, or a strong exposure to market story that supports the fair value. Disclosures, where most liability lies. Now, let's talk about the second major landmine, disclosures. A lot of people assume it's probate, it's as is, so disclosures don't matter. That assumption is where lawsuits come from. And here's something most families don't realize. A lot of agents who aren't probate trained will hand an executor the standard California seller disclosure package, like the TDS or SPQ, and said, just fill these out like a normal seller. That can be a major mistake because an executor is usually not living in the property. They often don't have personal knowledge of the home's day-to-day history. So when you're pushed to answer a long list of questions as they were the owner-occupant, they can accidentally guess or over-disclose or under-disclose because they simply don't know. And that's how unnecessary liability gets created. In a probate or fiduciary sale, the goal is not fewer disclosures. The goal is the right disclosures. Deliver the right way with the right fiduciary addendums that have clarity, capacity, and knowledge limits, so the state is protected. That's the difference between a generalist and a probate specialist. You know what disclosures are truly required, what must be delivered through proper statutory reports, and what addendums are needed to protect the executor and the estate without exposing them to unnecessary risk. Now, here's the disclosure categories that still trip people all the time. Natural hazard disclosure, lead-based paint, and disclosure for alters homes. Compliance like smoke detector and carbon monoxide detectors, water heater bracing, those are exceptions. They must be delivered. HOA documents and transfer requirements if there's an HOA. And here's the big point. Probate problems aren't always about price. They're about liability and cancellations. Let's talk the pocket listing risk. Now, the most dangerous advice I hear in probate sales is this: let's sell it off market. I have a buyer, it's easier, no signs. Sometimes there are legitimate reasons to limit exposure: privacy, sensitivity, family dynamics, creditor issues. But here's what cannot happen. You can't skip exposure, skip proof of value, and hope nobody questions it later. Because an executor or administrator, you have a fiduciary duty to pursue fair market value. If you sell quietly for one number and later someone claims the market supported more, you've created liability. Transparency is your legal shield. When the home is properly exposed, you can show we marketed, we created competition, we achieved fair market value. That protects the estate and it protects you. Now, keeping buyer committed during the notice period. So, how do you keep the buyer committed while the legal dock runs? This is where Aragone's strategy shows up. We set expectations up front. Before emotions and pressure hit, we tell the buyer and the buyer's agent, this is a probate sale, there's a legal notice period, we'll communicate throughout, the goal is clean title, clean process, and smooth close. If your agent can't clearly explain the process timeline, buyers get nervous, and nervous buyers cancel. You need a team that knows how to help keep the deal together while the legal steps happen. Now, tips. Check your authority. Is it full authority or limited authority? Know it before you accept an offer and promise a timeline. Understand the 90% rule if court confirmation is required. Know the probate referee appraisal value and how it affects viable offers. Confirm the notice list and the addresses early. If someone is estranged or out of state, don't guess, get it right. Talk with your attorney. Build the disclosure packet early. Don't wait until the buyer asks. Choose experience over convenience. A generalist can cost you time, money, and legal exposure. A probate sale isn't just a real estate deal. It's a legal process wrapped around a real estate transaction. And the best way to protect yourself is simple. Do it transparently. Do it correctly. Do it with the right team. If you just got letters testamentary and you're unsure of your options, the probate process, or the fiduciary responsibilities, and you have questions before you make any decision, get a second opinion before you move forward. Use the confidential link in the description to request a private strategy call with my team. And if you want that second opinion, comment second opinion, like and share. I'm Paula Aragone at Aragone & Associates. We maximize value and we minimize stress. And remember, strategy is what we do. I'll see you next week.